SwayamPrabha. Digital India. Educated India.
Hello friends, welcome to the class of Maritime Law. I am Dr. Ashutosh Acharya, Senior Assistant Professor, Law Center 2, Faculty of Law, University of Delhi. The fourth module that we have today is Basic Concepts of Law of the Sea, Part 3. In the previous 2 and 3 classes, we have discussed the historical background of maritime law, wherein we also discussed about the historical background of the law of the sea. We also have discussed the maritime zones differently placed as they go beyond the coastal state. The first one being the territorial sea, the second one being the contiguous zone, the third one being the exclusive economic zone, and then beyond that you have high seas. In territorial sea, we have seen in last to last class as well as in the last class that there is the intensity or the gravity of sovereign rights is maximum. It is considered to be a legislative area. Territorial jurisdiction comes into being. And when we go ahead into the contiguous zone, that is the 24 nautical miles starting from the baseline, we see that only certain custom related laws, fiscal related laws, sanitary related laws, etc. are to be taken into account. Extraterritorial jurisdiction comes into being as far as contiguous zone is concerned. And then we see marine scientific research, extraction of resources, wherein legislative jurisdiction does not come into being. And this extension goes up to 200 nautical miles starting from the baseline, from the point where territorial sea or contiguous zone is measured. So, beyond 24 nautical miles, that is in the rest of the 176 nautical miles left after territorial sea and contiguous zone, only economic rights exist which are exclusive in nature, and this region is known as exclusive economic zone. As it came, it was codified. It came for the purpose of codification. It was a solution given to the developing and least developed countries. And why this solution? The history behind it. The history has been that there are few developed countries, there are few countries that are in advantageous position as far as science and technological development is concerned. So, in order to provide equal status, in order to give them equal share as far as sea resources are concerned, in order to avoid any kind of subjugation in future by the developed countries, in order to avoid any kind of apprehension that would be prejudicial to the interest of the developing and least developed countries. How least developed countries or developing countries can utilize in equal manner the sea resources? How can they have exclusive rights over the sea region? How can their rights be protected as far as economic aspects are concerned internationally? So, taking into all of those things into account, post third conference we see through various proposals by African and Asian countries, the protection was or protectionist regime was placed in the form of exclusive economic zone. But the traditional concept prior to EEZ as it existed, which provided for exclusive economic rights to states, was rights coming under the domain of continental shelf or the recognition of continental shelf. The advanced states that were seafaring nations or the states that were extending their sovereign rights over sea as they realized the economic importance of sea water, they wanted to have and establish continental shelf, because continental shelf is the region where you get all the resources, sea resources, and therefore they wanted sovereign rights, economic sovereign rights to be placed, to be recognized and not to be hindered and opposed as far as coastal states are concerned. These things are not also very simple in the situations wherein, and also were not simple in the situations wherein a state is extending its continental shelf to an appreciable extent and it has an state opposite situated to it. The distance between, let us say, two states is 100 nautical miles. If state A and state B are situated opposite to each other in such a scenario, what should be the division of the sea water? Whether it should be divided 50-50, that is 50 nautical miles to state A and then 50 nautical miles to state B, what should be done in such situation? What should be done if, let us say, in first half, that is the 50% of state A is composed of exclusive fishing zone and the second 50% which is in proximity to state B does not have a fishing stock or fishing zone? Can state B be allowed to do fishing in the 50% zone of state A? How to settle such issues? How to demarcate continental shelf? Such are the issues that will be discussed in today's module or in today's class. So, we have this part 3 is specifically focused primarily on continental shelf, largely due to its historical importance and its 20th century, 21st century economic importance. So, friends, the learning objectives for the day would be to learn about the importance of continental shelf, to understand the legal status of continental shelf in detail and then to learn the nuances of delimitation of continental shelf. And along with this, we will also discuss in the last part of today's module the dispute settlement regime available under United Nations Convention on Law of the Sea, as we see a number of disputes or different types of disputes may arise. And when such disputes arise between two states with respect to continental shelf or with respect to law of the sea or with respect to any subject matter that we have discussed in the previous modules and classes, what does UNCLOS say as far as dispute resolution mechanism is concerned? Well, friends, starting with the understanding of the continental shelf, as you can see, if we have the coast or the baseline here, the water column extends to a considerable limit. But then if you look at United Nations Convention on Law of the Sea, it gives you territorial waters which may be 12, then contiguous zone which may be 24 from here, and then you can have your EEZ also, which can be only up to 200 nautical miles. At the same time, we see that United Nations Convention also allows states to go beyond 200 nautical mile, and when it does so, it lays down a limit that you may go beyond 200 nautical mile, but it should not go or it should not be more than 350 nautical miles. So, in exceptional scenarios only a state can have 350 nautical miles up to which the continental shelf can be extended. So, as per traditional connotation, if this is territorial water up to 12 nautical mile, or traditionally it may be up to 6 nautical mile or 10 nautical mile, but now if it is 12 nautical mile, from territorial sea to 350 nautical mile altogether can be considered to be continental shelf. But it is an international, it is a traditional concept which is recognized in United Nations Convention on Law of the Sea. Since it was traditional, since states already had practices fixed with respect to continental shelf, but not all, but powerful, developed, scientifically and technologically advanced states were having it. So, it was difficult to ignore and limit continental shelf. So, therefore, as a solution to this particular aspect, they recognized the traditional practices, the traditional extensions, and also came up with a solution by providing EEZ to those states who were not having traditional practices or conventional practices with respect to extension of continental shelf. Now, in what scenario and how it can extend, or the continental shelf can be extended beyond exclusive economic zone. So, friends, if you see, the rule largely is to identify a point where there is the depth of the sea is 2500 meter isobath. So, the constraint 1 is distance constraint 1, and that is 350 nautical miles from the baseline, as I have already told you that it cannot go beyond 350 nautical mile. At the same time, the second constraint is with respect to depth, that is 100 nautical miles, 100 meters from the 2500 meters of isobath. That is the first constraint, and that is the second constraint, that this extension would be from this particular point where the sediment or the depth of the sea from the water column to the sediment accumulation is 2500 meters isobath. From this point carrying up to this point, it should not exceed 100 meters, that is 100 meters from 2500 meters isobath. So, 350 nautical miles either up to 2500 meters of isobath depth, or second constraint 100 meters where there is sediment accumulation, starting from the point where the depth of the sea is 2500 meters isobath. So, these are the two constraints that we see, which goes beyond 200 nautical miles of EEZ. Now, to better understand, let us see another picture wherein we will see that if such is the continental shelf, the slope of the continental water would be divided into different parts. If you look at sea generally, you see that depth of the sea keeps on increasing. The depth of the sea keeps on increasing, and as it increases, we see that this portion where there is sudden drop and the slope which provides for sudden drop is known as continental slope, as given in this particular picture as well. So, this is the slope, and as this particular drop reduces and then there again sediment accumulation, we call this particular point the continental rise. Here, with these different regions, we identify as the deeper continental shelf gets, the more the resources can be found, and the limit to which is attached with the continental shelf is that it cannot go beyond a particular point where the depth is 2500 meters of isobath, or 100 meters starting from that particular point at the max. Now, understanding this particular aspect, that what is continental shelf and to what extent it can be extended as far as United Convention on Law of the Sea is concerned, what has been the importance of continental shelf? It is largely economic in nature, since there was realization was mainly just before the Second World War. Extensive oil and gas reserves were found. Around 90% of the total value of minerals are taken from seabed. By mid 1990s, offshore oil and gas production accounted for around 1/3 of total world power production. Placer deposits of heavy minerals containing metals such as tin, titanium, chromium and zirconium. Diamonds from the seabed of Namibia. Lead, zinc, gold, silver, copper in Red Sea and other areas. Important fisheries such as oysters, clams, lobsters, crabs. Now, since we have this economic importance largely coming into being around Second World War, post Second World War, we see drilling and extraction of minerals and all these materials, all these resources, especially oil, getting extracted. be it North Sea, Mediterranean Sea, Pacific Ocean, Atlantic Ocean or any other ocean. We find different kinds of resources in different oceans and sea areas, and there is a race towards extraction of resources. And obviously, as I already told you, the advanced states, the states who were in a position to extract these resources, were better situated to take away all these resources, and therefore, the concerns of the developing and least developed countries had to be taken into account. And as a result, we see United Nations Convention on Law of the Sea 1982 does take into account the concerns of these states, and while it does so, it provides for a certain legal status of the continental shelf. Now, there is a historical background to it as far as legal status of continental shelf is concerned, and it gets recognized under United Nations Convention on Law of the Sea. The extension that we see, which goes beyond 200 nautical mile, is an example of such recognition. Now, if you look at the history, the question was always that whether to consider continental shelf as res communis or res nullius. What is the difference between res communis and res nullius? Res nullius is an area which does not belong to anyone, which was a property not belonging to anyone, that means which belongs to everyone. So, res communis is the property which belongs to the community, but here if you look at the practice of states, it was not considered to be res communis, rather res nullius, that is, whosoever discovers first and whosoever claims first will have the right over that particular area. And that is what has been recognized also, that continental shelf becomes an area which will be utilized by the state in proximity to it. Res nullius is largely an idea used in the territorial part or for the land territory part as far as possession is concerned, as far as settling down of ownership is concerned. Continental shelf is largely based on proximity in contiguity. So, a state in proximity to the sea area would be in a better position or will have the right also under the law to extract resources, utilize it, have ownership over the economic resources found within that particular sea region. Now, developed and scientifically advanced states were in a better position to claim and achieve effective occupation on the resources available at high seas. Therefore, efforts to develop a legal regime started around mid 20th century. We see that in 1945, President Truman of United States of America gave a proclamation, and he said, "The government of United States regards the natural resources of the subsoil and seabed of the continental shelf beneath the high seas, but contiguous to the coast of the United States as appertaining to the United States, subject to its jurisdiction and control." It is this reason, friends, we see that United States of America has yet so far not ratified United Nations Convention on Law of the Sea, because they do not want to be restricted as far as utilization of resources in high seas or is concerned, or extension of continental shelf is in question. The restriction provided will be applicable then only on the states that have ratified the United Nations Convention on Law of the Sea. This was largely based on contiguity and reasonableness. Of course, this proclamation does not mean that United States of America will take into account the continental shelf or exclusive economic zone of any other state. It will not enter into that particular portion, but at the same time, wherever there is an extension or wherever there is an high sea available in which can be considered to be attached to the coastal state of United States of America, then such extension will not be restricted up to 350 nautical mile or 200 nautical mile. It may go up to 1000 nautical miles. So, due to such restrictions, it has avoided signing or ratifying the United Nations Convention on Law of the Sea. However, largely almost other practices are of the same nature as provided in United Nations Convention on Law of the Sea, which may be with respect to territorial waters, rights and duties provided in territorial waters. Rest of the things remains same. Inconsistency in early practice, as some claimed jurisdiction and control while some others claimed sovereignty over the shelf as such. Latin American countries claimed sovereignty over suprajacent waters and airspace above. In 1958, at the Geneva Conference, it was generally accepted by about 20 states that rights of coastal states over continental shelf exists. We can see in 1969, in North Sea continental shelf cases, ICJ had stated that the rights of the coastal state in respect of the area of continental shelf that constitutes a natural prolongation of its land territory into and under the sea exist ipso facto and ab initio by virtue of its sovereignty over the land, and as an extension of it in an exercise of sovereign rights for the purpose of exploring the seabed and exploiting its natural resources. In short, there is here an inherent right with respect to exploitation and exploration of continental shelf, which is contiguous to the coastal state. We will discuss North Sea continental shelf cases in detail also today itself. Confluence of continental shelf and EEZ, as we see that continental shelf starts from the point where territorial sea ends and can go beyond exclusive economic zone. So, we see there is a larger amount of confluence that comes into being as far as EEZ or continental shelf is concerned. Therefore, we can say that all EEZ is continental shelf, but all continental shelf may not be EEZ. EEZ has to be claimed, whereas a right of continental shelf is ipso facto. So, EEZ is a right which a state attains or gains once it signs United Nations Convention on Law of the Sea, because it is a right or rights appertaining to it are there by virtue of existence of a convention. It is not traditional or it is not customary in nature, whereas the rights pertaining to continental shelf are customary in nature, and therefore, even if a state has not signed or ratified United Nations Convention on Law of the Sea, even then it has the right over continental shelf. It can explore, it can exploit the resources available in the continental shelf, which is ipso facto and ab initio, since EZ is claimed under UNCLAUSE, whereas claim over continental shelf is customary in nature. Article 76 gives us the definition of continental shelf, and it says, firstly, the continental shelf of a coastal state comprises the seabed and subsoil of the submarine areas that extend beyond its territorial sea throughout the natural prolongation of its land territory. So, continental shelf is a natural prolongation of the land territory, which is also recognized under Truman's proclamation in 1945. This Truman's proclamation is used as a statement which supports the idea of utility of continental shelf by the states whose natural prolongation is in the sea, and that particular part of sea is considered to be continental shelf. Therefore, if it is a natural prolongation of its land territory to the outer edge of the continental margin or to a distance of 200 nautical miles from the baselines from which the breadth of the territorial sea is measured, where the outer edge of the continental margin does not extend up to that distance, the continental shelf of a coastal state shall not extend beyond the limits provided for in paragraph 4 to 6. We will come to it. The continental margin comprises the submerged prolongation of the land mass of the coastal state and consists of the seabed and subsoil of the shelf, the slope and the rise. So, as we had already seen in a pictorial representation, the downward land area would be the slope, and the subsoil, that is the soil beneath the seabed, all of which will be considered as part of continental shelf, and exploration and exploitation of all that area would fall under the right of the coastal state as far as exploitation and exploration in continental shelf is concerned. It does not include the deep ocean floor with its oceanic ridges or the subsoil thereof. 4 says, that is clause 4 of article 76 says, for the purposes of this convention, the coastal state shall establish the outer edge of the continental margin wherever the margin extends beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured by either a line delineated in accordance with the paragraph 7 by reference to the outermost fixed points, at each of which the thickness of the sedimentary rocks is at least 1% of the shortest distance from such point to the foot of the continental slope, or a line delineated in accordance with paragraph 7 by reference to fixed points not more than 60 nautical miles from the foot of continental slope. So, the extension of the continental shelf beyond 200 nautical miles would be taken into account, or would be applicable, or would be enforced by taking into account the first part and the second part as given under clause 4a of section 76. Clause B says, in the absence of evidence to the contrary, that is, if the 1% sedimentation is missing, the foot of the continental slope shall be determined as the point of maximum change in the gradient at its base. Clause 5 says, the fixed points comprising the line of the outer limits of the continental shelf on the seabed drawn in accordance with para 4 a first and second either shall not exceed 350 nautical miles from the baselines from which the breadth of the territorial sea is measured, or shall not exceed 100 nautical miles from the 2500 meter isobath, which is line connecting the depth of 2500 meters. That is, if you look at the first picture that we have here is, then we can see that this is the point of 2500 nautical 2500 meter isobath distance. From here it should not go beyond 100 nautical miles. So, this 100 nautical mile is the maximum from the point of 200 nautical miles of EEZ. Now, this point may be, this 200 nautical mile may be here, and this 2500 meter isobath point may be here. So, it may be measured from here also. So, since the maximum limit is 350 nautical mile, it may be 300 nautical mile, it may be 250 nautical mile also, depending on the geographical condition of that particular continental shelf. It further says, the coastal state shall delineate the outer limits of its continental shelf, where that shelf extends beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured by straight lines not exceeding 60 nautical miles in length, connecting fixed points defined by coordinates of latitude and longitude. Information on the limits of the continental shelf beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured shall be submitted by the coastal state to the Commission on the limits of the continental shelf. So, we have a commission on the limits of continental shelf. Such extension of continental shelf should be informed to the Commission on limits of continental shelf, set up under Annexure 2 of the United Nations Convention on Law of the Sea on the basis of equitable geographical representation. The Commission shall make recommendations to coastal states on matters related to the establishment of the outer limits of their continental shelf. The limits of the shelf established by coastal state on the basis of these recommendations shall be final and binding. The coastal state shall deposit with the Secretary General of United Nations charts and relevant information, including geodetic data permanently describing the outer limits of its continental shelf. The Secretary General shall give due publicity thereto. And lastly, the provisions of this article are without prejudice to the questions of delimitation of the continental shelf between states with opposite or adjacent coasts. So, if you look at the last clause, that is the 10th clause, as it says, the provisions of this article are without prejudice to the questions of delimitation of continental shelf between states with opposite or adjacent coasts, we see that states through agreement, bilateral agreements or multilateral agreements can divide the sea water present either between them or adjacent to them, for which we will also discuss a case law which is North Sea continental shelf cases in the upcoming slides. Article 77 talks about rights of coastal state over the continental shelf. It says the coastal state exercises over the continental shelf sovereign rights for the purpose of exploring it and exploiting its natural resources. Therefore, other states are prohibited to explore or exploit the natural resources of the continental shelf of the concerned coastal state whose sovereign rights are there. If it does so, prohibitions can be laid out by the coastal state. The rights referred to in paragraph 1 are exclusive in the sense that if the coastal state does not explore the continental shelf or exploit its natural resources, no one may undertake these activities without the express consent of the coastal state. So, there might be a situation where coastal state is not interested in exploitation of the continental shelf attached to the coastline of the concerned coastal state. In such a situation, any other state cannot start exploiting the continental shelf of the given coastal state or the coastal state to whom such continental shelf belongs, on the reasoning or on the rationale that the concerned coastal state, since it is not using, the other state can use it. It is the prerogative of the coastal state to use it or not to use it. If it wants other state to use it, it may enter into an agreement and allow the other state to use the continental shelf of its attached to that particular coastal state. Further, the rights of the coastal state over the continental shelf do not depend on occupation, effective or notional, or on any express proclamation. So, the legal status is pretty much clearer that the continental shelf's right will reside with the coastal state which is in proximity. The requirement is the political sovereign right existing as far as land territory is concerned. Once you have rights over land mass, automatically that particular political entity sovereign rights will be endowed on the continental shelf that is contiguous to that particular coastal state. The natural resources referred to in this part consist of the mineral and other non-living resources of the seabed and subsoil together with living organisms. So, it is not only non-living organisms, but also living organisms that fall within the domain of rights of over continental shelf belonging to sedentary species, that is to say organisms which at the harvestable stage either are immobile on or under the seabed or are unable to move except in constant physical contact with the seabed or the subsoil. Article 78 talks about legal status of the superjacent waters and airspace and the rights and freedoms of other states. The rights of the coastal state over the continental shelf do not affect the legal status of the superjacent waters or of the airspace above those waters. The exercise of the rights of the coastal state over the continental shelf must not infringe or result in any unjustifiable interference with navigation and other rights and freedom of other states as provided for in this convention. So, since this convention, that is United Nations Convention on Law of the Sea, provides for freedom of navigation to all the ships, the freedom of passage is applicable to all the ships in all the areas of sea water, but at the same time there are considerations with respect to innocent passage. But friends, let us note here, and I am pointing this out here again as we had discussed in the last class also, that this freedom of navigation is subjected to certain limitation, and this limitation comes in the form of innocent passage, that the passage must be innocent. However, this innocence is restricted only up to 12 nautical miles, that is applicable only in territorial waters. So, even if a submarine has to cross, it has to come on the surface and show its flag, only then the passage of the submarine can be considered to be innocent, but that rule is applicable only in territorial waters and not beyond that particular 12 nautical mile. So, if a submarine is travelling through continental shelf of any other state, then the limitation of innocent passage will not come into being. So, there are larger and greater rights that are available for the ships as far as right to navigate or freedom of navigation is concerned. The restrictions pertaining to innocent passage does not come into being. The restrictions that come into being as far as these ships are concerned are only with respect to exploitation and exploration of living, non-living resources which are of economic importance to the coastal state. So, the sovereign rights are limited in continental shelf, and at the same time in corollary or contrary to which the ships that navigate through those routes also have limitations and restrictions as far as continental shelf is concerned. Article 79 talks about submarine cables and pipelines on the continental shelf. All states are entitled to lay submarine cables and pipelines on the continental shelf in accordance with the provisions of this article, subject to its right to take reasonable measures for the exploration of the continental shelf, the exploitation of its natural resources, and the prevention, reduction, and control of pollution from pipelines. The coastal state may not impede the laying or maintenance of such cables or pipelines. I will repeat again that the subject to its right to take reasonable measures for the exploration of continental shelf. So, if there is some exploration of continental shelf that is undergoing or that is to undergo the exploitation of its natural resources, or if any natural resources is to be extracted and exploited, let us say an oil is found and oil field is established in that particular region of continental shelf, if a particular region is rich in marine resources and it has to be prevented or protected, pollution related aspects are to be taken care of, then in such a situation pipelines or submarine cables can be restricted from being laid down. The coastal state may not generally impede the laying or maintenance of such cables or pipelines. So, generally no such restrictions will be placed as far as any pipeline or cables are placed in the continental shelf, but where there is exploration and exploitation and preservation and protection part comes into being, then an alternate could be provided as far as such pipelines and cables are concerned. The delineation of the course for the laying of such pipelines on the continental shelf is subject to the consent of coastal states. So, as we have already identified under clause 2 of article 79 that there is a general right of other states to lay down pipelines and submarines from that particular continental shelf region of the coastal state. However, at the same time they must take permission from the coastal state, since an area from which such cables are passing or pipelines are passing, that particular area could be a protected area, that particular area could be an area where oil has been found or extraction has to take place or is taking place. So, taking into account all such situations, practical scenarios, factual scenarios, the coastal state could provide with an alternate area where cables or pipelines could be laid down, so that those cables and pipelines are also not adversely affected, which will be negatively impacting and affecting the states between whom such pipelines and cables have been placed. Nothing in this part affects the right of the coastal state to establish conditions for cables or pipelines entering its territory or territorial sea, or its jurisdiction over cables and pipelines constructed or used in connection with the exploration of its continental shelf or exploitation of its resources, or the operations of artificial islands, installations and structures under its jurisdiction. So, in continental shelf state can come up with any kind of temporary or permanent installations. It can also go ahead by establishing an artificial or building an artificial island as well. 5 says, when laying submarine cables or pipelines, states shall have due regard to cables or pipelines already in positions. So, if the coastal state is laying down its own cables and its own pipelines, it cannot say the other states who has already laid down their cables and pipelines to be removed or to be taken out. In that scenario, if already cables and pipelines have been established, the coastal state, if now after there is already situated or placed pipelines and cables, cannot remove those cables or cannot remove those pipelines. Rather, it has to take into account the existence and placement of those cables and pipelines and avoid any damage to already existing cables and pipelines which belong to some other state. Article 80 talks about artificial islands, installations and structures on the continental shelf, and it says Article 60 applies mutatis mutandis to artificial islands, installations and structures on the continental shelf. And Article 60 says, in the EEZ, that is exclusive economic zone, the coastal state shall have the exclusive right to construct and to authorize and regulate the construction, operation and use of artificial islands, installations and structures for the purposes provided for in Article 56 and other economic purposes. Installations and structures which may interfere with the exercise of the rights of the coastal state in the zone, the coastal state shall have exclusive jurisdiction over such artificial islands, installations and structures, including jurisdiction with regard to customs, fiscal, health, safety and immigration laws and regulations. So, whatever rights a state is having as far as exclusive economic zone is concerned, either with respect to artificial island or installations or structures to be built in EEZ, same rights are also provided in the region where continental shelf exists, especially in the region where continental shelf extends beyond exclusive economic zone. Same rights also extend along with the extension of continental shelf. Article 81 says drilling on the continental shelf. The coastal state shall have the exclusive right to authorize and regulate drilling on the continental shelf for all purposes. Article 82 says payments and contributions with respect to the exploitation of the continental shelf beyond 200 nautical miles. So, a state can have a continental shelf which goes beyond 200 nautical mile, but at the same time it has certain dues to be paid as far as that extended part is concerned. And it says the coastal state shall make payments or contributions in kind or in respect of the exploitation of the non-living resources of the continental shelf beyond 200 nautical miles from the baselines from which the breadth of the territorial sea is measured. So, let us assume that an oil has been discovered by a coastal state beyond 200 nautical miles, but within 350 nautical miles. So, when such oil is extracted, International Seabed Authority will give permission in such scenarios. Let us say oil is discovered beyond 350 nautical miles also, then exclusive permission is required from International Seabed Authority. But if it is within 350 nautical miles, but beyond 200 nautical miles, exclusive permission may not be required. But at the same time, since such an extension has been provided, then in such a scenario, based on certain considerations of course, which we have already discussed, then in such a scenario, payments has to be made to certain particular international authority, and it says that the payments or contributions shall be made through the authority which shall distribute them to state parties to this convention on the basis of equitable sharing criteria, taking into account the interests and needs of developing states, particularly the least developed and the landlocked among them. Further, Article 83 talks about delimitation of continental shelf between states with opposite or adjacent coasts. Now, this is an issue which was long pending, and it came into being for the first time at a larger fora, as we see in North Sea continental shelf cases. Since prior to North Sea continental shelf cases, we see that under Geneva Convention 1958, Article 6 of the Geneva Convention on Continental Shelf very clearly and easily gives the solution, wherein it says that wherever such dispute pertaining to division of continental shelf comes into being, the states must divide it by applying equidistance principle, that is, they must divide the portion of water equally. But that solution was a not so immature, not so mature solution. It's quite an immature solution, because all states are not situated opposite to each other. That is one problem. Even if they are situated opposite to each other, the geographical and morphological conditions of the two states situated opposite to each other might not be same. In such situation, equal distribution can be detrimental to the interest of any one of the state. What happens if states are situated adjacent to each other, one state, then second state, then you have third state? How will they divide the sea water equally? Again, it raises substantial challenges for these states to divide water equally. What about the situation where the coastline is not straight, the coastline either is convex in nature or concave in nature? We will understand this particular aspect through North Sea continental shelf cases just immediately after discussing this particular provision. So, in UNCLOS, such issues were already at table and they wanted to resolve. So, equidistance principle making rule in application as far as delimitation of continental shelf is concerned, equidistance principle was not an appropriate solution, and this was already realized. And therefore, equidistance principle could be a solution in simple scenarios, but cannot be a universal solution. It could be a solution, but could not be a universal solution. So, depending on different factual scenarios, different solutions are to be reached out. Therefore, 83 was brought into picture, and it says and talks about delimitation of continental shelf between states with opposite or adjacent coasts. Firstly, it says that the delimitation of continental shelf between states with opposite or adjacent coasts shall be effected by agreement on the basis of international law, as referred to in Article 38 of the Statute of ICJ, in order to achieve an equitable solution. So, it simply says that wherever there has to be delimitation, the law that must be applicable must be borrowed from Article 38 of ICJ, which talks about sources of international law. That is, if there is any international treaty or a convention, it must be made applicable. If there is international custom, that must be made applicable. And if both the scenarios are absent, then general principles of recognized amongst civilized nations could be applicable. So, either through primary sources or with the help of certain past judicial decisions, such a solution can be brought into picture as far as delimitation of continental shelf is concerned. So, therefore, treaty or signing a convention is the best solution as far as delimitation of continental shelf is concerned, and this must be done by taking into account equitable approach. So, depending on the factual scenario, depending on the circumstances, as far as relevant circumstances, as far as sea coast, coastline and availability of resources in the sea present in front of the coastal states are concerned, depending on all those circumstances, equitable division of sea water should be taken into account. Further, it says, if no agreement can be reached, that is Article 38 clause 1 subclause A, no agreement can be reached within reasonable period of time, the states concerned shall resort to the procedures provided for in part 15, that is with respect to settlement of dispute. So, then they can go for settlement of dispute. We have discussed in this module also in the last part of the of this particular class, that what are the different methods of settlement of dispute and which method of settlement of dispute could be taken into account in order to resolve the dispute pertaining to delimitation of continental shelf. Therein, a particular adjudicating body or dispute settlement body will be in a position to then settle the dispute between the adjacent states or states situated opposite to each other as far as delimitation of continental shelf is concerned. Pending agreement as provided for in paragraph 1, the states concerned in a spirit of understanding and cooperation shall make every effort to enter into provisional arrangements of a practical nature, and during this transitional period not to jeopardize or hamper the reaching of the final agreement. Such arrangement shall be without prejudice to the final delimitation. Fourthly, where there is an agreement in force between the states concerned, questions relating to the delimitation of continental shelf shall be determined in accordance with the provision of that particular agreement. Now, friends, let us discuss North Sea continental shelf cases, which is between Germany and Denmark and Netherlands. Now, what is the dispute? Let me simplify the factual situation. As you can see, Netherlands is situated here, Germany is situated in between Denmark and Netherlands, and this is the coastline as you can see, as far as all the three states are concerned, and in front of them we have North Sea. And as we see this North Sea, what happened is that if you look at the division between Netherlands and Denmark, it comes down to this particular point, and if you look at the division between Denmark and Germany, it comes down to this particular point. Now, what Denmark and Netherlands did was that they applied Truman's proclamation and argued for natural prolongation. Similarly, Denmark also argued for natural prolongation, and straight lines were drawn as far as their claim was concerned. As far as this overlapping portion is concerned, they drew a median line as in order to divide the share. So, this particular portion of share fall within the domain of Netherlands, and this particular portion of share then falls within the domain of Denmark, right. And this particular portion was left for Germany, which Germany objected to, as it was quite a lesser portion as compared to this particular whole area. And therefore, Germany as well as Netherlands and Denmark, along all these three countries, referred this particular dispute of delimitation to International Court of Justice. Now, when they went to International Court of Justice, we see, as you can in this picture also see, this is the general demarcation as far as Netherlands is concerned, as far as Denmark is concerned, and only this much portion was left for Germany. Now, in order to resolve this particular dispute, we see that Denmark and Netherlands placed their arguments on the basis of natural prolongation, and it says, and it wished prolongation to be effected on the basis of equidistance principle. Denmark and Netherlands argued that we have applied equidistance principle. Now, it is pertinent to note here that Denmark and Netherlands both were party to Geneva Convention on Continental Shelf 1958, and therefore, Article 6 of the Geneva Convention on the Continental Shelf argued for or provided a solution of delimitation in the form of equidistance principle, and therefore, they said, since we are party to Geneva Convention on Continental Shelf, we are bound by Article 6, and therefore, we have applied equidistance principle and divided the water equally. The principle of equidistance is meant to be customary international law was also claimed by Denmark and Netherlands. They said that since it is a convention and it is the only solution that is available as far as delimitation of continental shelf is concerned, and it is a necessity, it is a legal necessity that all states accept as far as legal solution with respect to delimitation of continental shelf is concerned. Therefore, Germany is also bound. Now, we must note here that Germany is not or was not party to Geneva Convention on Continental Shelf, and therefore, Germany argued that since it is not a party to Geneva Convention on Continental Shelf, the principle of equidistance rule is not applicable on Germany. Therefore, it may be applicable on Denmark and Netherlands, but Germany is not bound by the equidistance principle levied in or laid down in Article 6 of the Geneva Convention on Continental Shelf. Now, friends, what does it say? It says that where the same continental shelf is adjacent to the territories of two or more states whose coasts are opposite to each other, the boundary of the continental shelf appertaining to such states shall be determined by agreement between them. In the absence of agreement, and unless another boundary line is justified by special circumstances, the boundary is the median line, every point of which is equidistant from the nearest point of the baseline from which the breadth of the territorial sea of each state is measured. So, we see that equidistance principle is the rule provided by Geneva Convention of Continental Shelf in 1958. So, whether it has crystallized, this Article 6 has crystallized into customary rule of international law, court denied this particular claim that Article 6 has culminated into customary rule of international law. Since the geographical and geomorphological conditions of states that are situated either opposite to each other or adjacent to each other are not same or not in similarly situated to each other, and the geographical and geomorphological conditions could be disadvantageous to certain states and could be advantageous to certain other state. If you look at this particular case, you will note here that the coastline of Germany is concave in nature and the coastline of Netherlands and Denmark is convex in nature, which gives an advantageous position to Netherlands as well as to Denmark to extend their line to an appreciable extent, and deny Germany of a substantial share of water. So, due to this particular geographical or geomorphological condition, which could be relevant circumstances as far as delimitation of continental shelf is concerned, was ignored to a larger extent, and Article 6 of Geneva Convention also ignores this particular aspect, which was recognized in North Sea continental shelf cases, and it was said that Article 6 of the Geneva Convention on Continental Shelf is not applicable on Germany. Firstly, the apportionment theory was rejected. The division should be made, court said, by applying equitable principle, and it must be finalized by signing an agreement. And therefore, while it is done, while equitable distribution is done, relevant circumstances of the region must be undertaken. And if you see, finally, all the three states signed an agreement, and an extended region or extended North Sea area was provided to Germany. Certain fishing rights in certain areas was also given to Germany as far as the agreement between Germany and Netherlands and Denmark is concerned, post the judgment of North Sea continental shelf cases. Now, we also see that once a dispute comes into being under United Nations Convention on Law of the Sea, Part 15 of the UNCLOS 1982 talks about settlement of disputes. It provides for compulsory procedure entailing binding decisions. Article 286 says application of procedures under this section, which is subject to section 3. Any dispute concerning the interpretation or application of this convention shall, where no settlement has been reached by recourse to section 1, be submitted at the request of any party to the dispute to the court or tribunal having jurisdiction under this section. Article 287 talks about choice of procedure, which is mandatory upon almost all the parties to either choose any of the following procedures. So, there are 4 procedures that are provided under this particular provision. So, it says when signing, ratifying or acceding to this particular convention, that is UNCLOS, or at any time thereafter, a state shall be free to choose by means of a written declaration one or more of the following means for the settlement of disputes concerning the interpretation or application of this convention. That is, it can either choose ITLOS or can choose ICJ or can choose arbitral tribunal constituted in accordance with Annex 7, or it may choose a special arbitral tribunal constituted in accordance with Annex 8 for one or more of the categories of disputes specified therein. Further, it says that a declaration made under para 1 shall not affect or be affected by the obligation of a state party to accept the jurisdiction of the seabed dispute chamber of the International Tribunal for the Law of the Sea to the extent and in manner provided in Part 11, Section 5. A state party which is a party to a dispute not covered by a declaration in force shall be deemed to have accepted arbitration in accordance with Annex 7. So, wherever a state fails to choose any one of the mode of dispute settlement, automatically it will be deemed that it has chosen arbitration under Annex 7 to be the mode of dispute settlement. If the parties to a dispute have accepted the same procedure for the settlement of dispute, it may be submitted only to that procedure unless the parties otherwise. So, if there is difference of forum that the parties has chosen, if one of the party has chosen ITLOS, the other party has chosen ICJ, either they can agree, come to a conclusion that one particular forum will be used for settlement of dispute. In case of non-agreement, arbitration will be considered to be appropriate mode of dispute settlement. And lastly, Article 288, which talks about jurisdiction, a court or tribunal referred to in Article 287 shall have jurisdiction over any dispute concerning the interpretation or application of this convention, that is UNCLOS, which is submitted to it in accordance with this part. Court or tribunal referred to in Article 287 shall also have jurisdiction over any dispute concerning the interpretation or application of an international agreement related to the purposes of this convention, which is submitted to it in accordance with the agreement. The seabed disputes chamber of International Tribunal for Law of the Sea established in accordance with Annex 6 and any other chamber or arbitral tribunal referred to in Part 11, Section 5 shall have jurisdiction in any matter which is submitted to it in accordance therewith. In the event of a dispute as to whether a court or tribunal has jurisdiction, the matter shall be settled by decision of that court or tribunal. So, with this I conclude this particular module on basic concepts of law of the sea. Namaskar. Thank you.